I'm Gary Larimer, the university's Vice President of Development and Alumni Relations and a 1980 Dyson graduate. So it is great to see so many fellow alumni on the call. We really appreciate in a late July day on a 12 noon call that so many of you have found the time to join us. Thank you very much. We're already up over 60 participants on the call. It should be a very interesting conversation. And we have found some great success in connecting with our alumni during these many challenging months in our virtual events. We've had, over the past several months, a number of them ranging from topics for some recent graduates who are facing a little bit of a different world to a 1-hour session on Da Vinci. And we've been able to connect with hundreds of you, and we really appreciate it. The one advantage of our being able to do this virtually is we're joined by alumni from all over the country, and we appreciate it. Today's topic is Estate Planning 101. It is an informative session for you. You had the opportunity to submit some questions. You'll also have an opportunity to submit questions during the call as well. Part of the reason that we're offering this opportunity for you to hear from our panelists and moderator is that plan giving for a large percentage of the population, estate planning for a large percent of the population is becoming more and more important. We do recognize its importance by having individuals join the Edward J. Mortola Heritage Society when they have named Pace University in their estate plan. Much of it is helping to drive the future of our institution. We appreciate it, and we really can't thank you enough, and happy to answer any specific questions about the Mortola Society during the call or later today. A couple of ground rules for today's Zoom. I'll ask you all to mute your individual call-in so that we don't hear noise or racket in the background, and that you may submit questions through the chat function on the Zoom, and at about 12:45, we'll end the presentation, the panel presentation, and move to answering your chat questions. It's really my great pleasure to introduce our moderator for today's session, Horace Anderson, Dean of Pace's Elisabeth Haub School of Law. Horace himself, an attorney, was admitted into practice in 1997 and had 6 years of practice before joining the Pace faculty in 2004. Horace, while the Dean, also teaches courses on intellectual property, contract law, and data privacy. Horace was named an interim Dean in mid-2018, and just this past January in 2020, Horace was named the Dean of the Elisabeth Haub School of Law and has been a great friend and partner to Alumni Relations in the Development Office. So it's my pleasure to introduce Horace.
Gary, thank you very much for your kind introduction. Hello to all of our participants. Thank you for being with us. I'm really happy to be part of this panel discussion and to be kicking off Pace's Finance series as part of our virtual alumni events programming. Really thrilled to introduce our guests, our experts for today's panel. I'm going to start with Nat Perlmutter, who is a seasoned life insurance and investment executive leading Forest Hills Financial Group with more than 100 financial advisors across the New York metropolitan area. Forest Hills Financial Group is one of the nation's largest firms working with Guardian Life Insurance Company. Nat is past president of AALU, the Association for Advanced Life Underwriting, representing the top insurance professionals in wealth transfer and executive benefits. Nat is also a Pace alumnus, class of 1971, and a member of Pace's Edward Mortola Heritage Society, having included Pace in his estate plan. Next up, Robert Demmett, who's a CPA and financial professional with extensive experience in tax planning for high net worth individuals, including charitable giving and trust and estate planning. He's a longtime partner of Witham, which has nearly 1,500 professionals employed, also a Pace alumnus, class of 1984, and also a member of Pace's Edward Mortola Heritage Society. Next is Bridget Crawford, who has extensive experience as an estate planning lawyer, handling everything from simple estates to complex multi-million-dollar estates. She began her career as an associate in the Trust and Estates Department of Milbank LLP. She's a member of the American Law Institute and the American College of Trust and Estates Council. Since 2003, Bridget has been a member of the Haub Law faculty, where she teaches courses in wills, trusts and estates, tax, and corporations and partnerships. So welcome to all three of you, and thank you for giving of your time and expertise for the benefit of our alums. So let's start with questions about estate planning in general. So estate planning can be simple. It can also be very complex. A lot will depend on the size of the estate, types of assets, number of assets, ownership structure of the assets, family structure of the person planning the estate. And so we're going to jump in with our panelists giving their perspective on estate planning in general through their individual professional lenses. So let's start with Bridget. Bridget, can you take a few minutes to explain why a person should plan an estate, what they should seek to accomplish, and what are some of the basic parts, basic components of an estate plan?
First, I have to thank you for having me. I'm thrilled to be here. I'm thrilled to see so many of our alumni from the law school and all other parts of the university. There are 5 reasons that you want to have an estate plan. The first and foremost on many of our minds during this time of the pandemic are to make plans for a point of inability to make your own decisions, either for financial matters or health care. So you want to make known to family members, friends, and your doctors what your wishes are with regard to things like artificial ventilation. So that's our first reason to have an estate plan, to make plans for when you're alive but unable to make your own decisions. Second, an estate plan allows you to decide who gets what after you die. You don't want family members arguing over dad's jeans jacket, and so easier to write that down in a will if you know that a particular family member would value the jeans jacket more than someone else. Then you should be deciding who that is. If you do not, the government will decide. If you do not decide, the government will decide. So number 2 on my list of 5 reasons is so that you are in the driver's seat. Third, if you have minor children, it's incredibly important to have a will, because the will is the vehicle for designating who will be the guardian of your children if you die. Ordinarily, if you die with a spouse and minor children, the spouse would become the guardian. The trickier situation is if you and your spouse are simultaneously hit by a bus or get sick and die, you want to designate a guardian. Again, if you don't, the government will. Fourth reason, minimize family strife or disagreement at all times, but especially in times after a death when people are vulnerable and mourning. By having an estate plan, you can be more sure, never certain, you can be more sure that things will go smoothly. And then 5th, if you're lucky enough to have an estate over $11 million, you'd have the goal of minimizing taxes. So 5 reasons you'll want to have an estate plan. Just very briefly, what basic documents should absolutely everyone have? Number 1, a financial power of attorney. It doesn't have to be presently exercisable. It can spring into effect if you need it to. Second, you want a living will and a healthcare proxy to designate who will make decisions for your health and what your wishes are. And then third, you want to have a will. The will is also important because it appoints an executor. What does an executor do? That's the person who marshals all of the assets, in other words, cleans out the garage and the record collection, takes all of those assets, handles all administrative matters, starts the probate process, files the decedent's estate tax return, and generally is the point person for winding up the decedent's affairs. So a lot of things to think about here, but I'll leave it right there for now.
Thank you, Bridget. Thanks for setting the stage really for what everybody should be thinking about at this point. And now I'm gonna switch to Bob because Bridget gave us a lot of information. Not everybody is going to be in frequent contact with a lawyer. And you know, these are questions that can also come up in your line of work, Bob. So talk to us a little bit about the role that an accountant can play in helping a client think through estate planning issues. And you know, you're going to see clients maybe more frequently than they will see a lawyer, so that's an opportunity for you to have that sort of conversation with them as well. Talk to us about that.
Sure. Thank you, Dean Anderson. And thank you for the invitation to join this panel. So I like to think of our role as a CPA. We're the motivational speaker. So as you said, we see clients much more often than attorneys. I have clients who I see 10 to 20 times a year, either through calls or through visits. So that I'm the first professional as a CPA to hear about life events. People, you know, clients getting married second time, having children, getting divorced, you know, retiring. I'm the first one to hear that, most likely. And then I go into my motivational speech therapy, which is, this is a perfect time for you to see your attorney and talk about your estate planning. The way I like to talk to clients about it is, what does it cost you, right? Everyone's afraid, oh, I don't want to go to my attorney because they're going to charge me a fee. And it's a very, the process of doing a estate document is not an easy process. There's a lot of decisions that have to be made that you keep on saying, I'll procrastinate and I'll do it next time. But it's important to do it now. So I'd like to talk to clients about, spent many years building up your net worth, worked hard all your life. Now, what happens to your assets? Right. The first issue, of course, is how much does the government take? And that really motivates people, right? Mitigate how much the government takes. But it's also things like, you know, do you want your assets going to your in-laws? So your children get married, they end up getting divorced, they inherit assets. Do those assets go to your children's spouses, ex-spouses? So there's a reason to do planning there. What happens to your near and dear items? Many people have artwork or jewelry or just records or things that they find very valuable. Most of the time, the children don't want them, and will sell them. And it's a good time to talk to the children about, you know, what would you do with this asset if I gave it to you? And maybe I'll give it to, not give it to you, but I'll give it to your sister or your brother. So there's a lot of issues that come up when you talk about this, especially when you talk about a life event. I'm getting divorced. Great time to do your estate planning. Make sure if you're getting divorced that your ex-spouse is taking off of all the life insurance policies and taking off the pension plans as a beneficiary. These life events are great triggering points to generate estate planning. So that's the opportunity I have to refer to an attorney. And I always tell my attorney friends, they owe me a nice lunch for referring my clients to there and getting my clients to focus on their estate planning. But we accountants are very important. As most clients tell me, as a CPA, you're the one who knows the whole financial picture. So many of them say, that's why we're appointed as executors and trustees of trust, or or even just mentioned in the will as if there are issues, or that the estate should continue retaining the accountant, because he knows the various issues, the financial issues, and what's out there. I've had many clients say to me that, you know, not even their spouses know where all the assets are and what they own. So it's important for that. So we play a major role in the administration of the estate. An estate administration is a very large project. It's the tax filings. Even if you don't have a taxable estate, there are tax filings that are required, not only for the federal government, but for the state government. And these forms are different. They're not like your income tax return. They require a lot of information. They require a lot of documentation. You have to have your non-liquid assets valued by qualified appraisals. You have to list everything you own, joint property, everything that's owned, your automobiles. And it's very time consuming. And these documents are examined. It's not like an income tax return where the chance of examination is below, 5%. On an estate, especially a taxable estate, the chance of examination is much higher. It could be 50, 60, 70% of those tax returns are examined. So it's a very large project to administer an estate. And it's also something where we can help the executor. The executor is in a fiduciary role. He has fiduciary responsibility. And we can help them by accounting for all of the transactions and showing it to the beneficiaries to make sure there's no question that everything that he's done is proper, or she's done is proper, and that they follow the will. So the accountant has a very important role in the estate planning process.
Thank you, Bob. I'm going to make sure I tell all my attorney friends to buy lunch for an accountant that they know,
Yes.
at least one accountant that they know. Thank you for the role that you play. So Nat, life insurance and retirement assets can play a key role in an estate plan as well. Can you talk to us a bit about the types of life insurance and how policy or retirement asset can play a role in what an individual decides to do with their estate?
Sure. Thanks, Horace, and thanks for asking me to be part of the panel. There are two basic types of insurance, but before I get to that, we have in excess of 40,000 clients, policyholders, and every one of them, when we met them, were underinsured. And so many people spend so much time worrying about what type of insurance should I own versus owning the insurance. Because the insurance is a financial asset that no beneficiary ever said, oh, I got too much. This is what I have, right? So I'm going to break it down very simply. There's two types of insurance. One is term insurance. And what term insurance means is you're going to have insurance for a specified period of time. Could be 1 year, 5 year, 10 year, 20 year, could be 30 years. You should know Penn State many years ago did a study, and they showed that 1% of all term insurance policies result in a claim, and that's because they're actually computed not to be enforced when they're needed. But if you're part of the 1%, it's great. We provide lots and lots and lots of term insurance. It's a great starting product, so you can buy what we consider as the human life value. People should buy what they need, right? And then worry about how they convert it and how they change it over their life as it changes. And then you have permanent insurance. That's insurance that will definitely be in force when you need it, regardless of your age. And as an example, this happens to be an estate planning conversation. Term insurance has really no place in estate planning. It could be a starter, but it can never help you finish your estate plan because most people will outlive that. I'm going to be 73 in 2 weeks, and I can tell you how many of my friends and clients that couldn't wait to save money all their working lifetime, and now they go, "Ooh, I'm in my 70s. I thought I'd be an old man, or I'm not so old anymore." And they see a larger runway, and now they're planning, and all of a sudden the costs are so large compared to what they would have been if they would have had some better planning early on. So that's basically the two types. And I can go through a whole machination of all the different types of terminal, different types of permanent. But for this conversation, you just know that there are plans that go forever, and there are plans that go for a specified period of time. And the specified time is actually fabulous for business commitments, loans, mortgages, things that have a finite period. If you're worrying about that obligation, it's easy to match it up with the term policy. How does life insurance fit into an estate plan? It gives you liquidity at the time that you need it, because people think that they have stock, they have bonds, they have real estate. Those assets are correlated assets. They're going to go with the market up and down and sideways, so that it is possible that at time of death, some assets could be depressed. And if there was no other liquidity, right, you might be forced to sell assets that you want to keep for your family. Also, I'm not an attorney. We do lots of estate planning. We have attorneys and accountants on staff. So I'm going to make a statement that that Bob and Bridget will have to corroborate if I'm correct. And if I'm not correct, that's fine also. New York State's one of the very few states, even though the federal exemption is north of 11 million, the state exemption is 5 and change. But New York has a quirk in the law that no other state has, or very few states have. And if your estate is worth 10% more than that 5.4, whatever that state number is, you lose your entire credit. Let me just tell you what that means in real life. You owe an extra $944,000 in taxes, in state debt taxes. So if you have an estate and it's illiquid, and it's, I'm going to call a $6 million estate for the moment, it's a modest estate, right? And it's homes and maybe a building and a second home. Now all of a sudden there's a $944,000 New York State tax bill, death tax bill that people weren't planning for. Very painful, very, very painful. So life insurance brings liquidity into, and also as an example, I'll give you, we have a number of billionaire families, and I'll tell you my presentation that the billionaire families that own lots of real estate. I go, make believe you owned 4 cows. And what do the cows give you? Milk. So you have 4 cows and you have 4 pails of milk. So here's estate planning. Do nothing. And when you pass and your spouse passes, you have to sell 2 cows. Or during your lifetime, you could take half a pail or a piece of a pail, which is milk or rent, purchase the proper amount of life insurance to pay your estate tax, and then now you can keep all 4 cows to pass on to your family, or all 4 bills to pass on, buildings to pass on to your family, right? So it's just a question of what you want your legacy to be. Yes, Roz, I'm doing something on it. This is what's good about working home. My wife sees me on a presentation, and she still can't not talk to me with a packet. So I apologize for that, but I couldn't script it any better. Then you have business insurance, right, and exit strategy. So why is life insurance important in business situations? Number one, if you have a partner, shareholders, whatever the setup is, the corporate setup, if one passes away, in general, the will of your deceased partner may make that spouse your partner. So somebody might want to be partners with their ex-partners, the deceased partner's husband or wife, right? Most people don't, right? So if you have a buy-sell agreement or shareholders agreement in advance with either predetermined or formula benefit, and it's funded with life insurance, things move very easily. Also, one of the things that helped us garner thousands of clients is just asking one simple question, is do they have a loan, a business loan? And then we ask them if they can produce it, so we want to show them one paragraph. And the one paragraph we show them is, if a shareholder, a key person, is no longer a shareholder, the loans are callable. That's in almost every single business loan that people have. Now, what people say to us is, don't worry, our business is strong, no one's going to call our loan. And that might have been true prior to 2008. But after 2008, banks call strong loans before they call weak loans. Why is that? They don't want their loan ratio to go out of balance with how they are scrutinized and supervised these days. So anyone who owns a business and has a loan for the business, which is so many people, whether it's an SBA loan or a regular bank loan, there needs to be some additional financial planning done for those business owners to help alleviate some of that potential stress. And lastly, most businesses that we see, either because we're mostly in the family business marketplace, business was transferred from a parent or in-law, and they either know the pain of figuring out how to transfer the business because there was not enough money, or the people that had proper planning with enough life insurance so that they had the liquidity they need and the ease of passing the business brings it to life. So I think I'll stop there. Unfortunately, I could do this for like 10 hours, just this one little section of, and enjoy myself, but my wife would be coming in and out too many times. So I think I'll leave it at that for the moment.
All right, thanks, Nat. I next want to pick up on something that each of you hinted at, but I want to put it squarely in front of us. Estate planning can be emotional, right? And there's a huge emotional barrier to sitting down and having this type of conversation. I can't think of anybody I know who really relishes sitting down and having a conversation about the day they die. So what sort of things do you do or talk to your clients about to give them the incentive to overcome that reluctance? How do you get them to come and sit down with you and talk about the day that they die? We'll start with Nat.
So what's very interesting about that is we find that the main reason people procrastinate with their estate planning is what Bridget mentioned earlier. It has to do with who's going to be the guardian of the children and who's going to be the executor of the will. It has nothing to do with not knowing what they want to do with their assets. It's facing the family and having that conversation. So that's really what we see, right? What our role, though, is to show people that they can actually plan their estate to go where they'd like it to go. They can afford to purchase the needed liquidity, and it does not affect their current style of living. From my perspective, for us, right, it's people are so worried that to protect their estate, and give their children what they need, they do not want to change their style of living. So we have different cash flow analysis, and we have different programs and concepts to show them that there is a way to plan and not change your style of living. But I still would say the single biggest barrier is the first one, and that is who they pick as guardian and who they pick as an executor. And I think Bridget and Bob could really talk to that better than I can. But from our perspective is you can definitely plan and leave a good legacy regardless of your size of your estate, with proper planning and without changing your current style of living.
Bridget, what's your approach in dealing with those emotional barriers?
I really like Nat's advice, because my advice is very similar. The best thing your estate planner can say to you is, I hope you never need my services because your estate plan is so fantastic, it just runs on its own. Or you can sometimes get closer to people and understand their needs by telling them experiences that you've had. I recently counseled a woman in her 50s whose mother has severe dementia. The mother needs round-the-clock care. It is not a very wealthy family, but they can afford some home care. The mother has 2 adult daughters. The daughters cannot agree on precisely what type of care the mother needs. Even worse, the mom does not have a will, and one of the daughters in her 50s, also in her 50s, is about to go through a divorce. So if that mother were to die without a will, the assets would go, there's no spouse, it would go 50-50 to the 2 adult daughters, one of whom is going through a divorce. And that's exactly the situation you never want to be in. All of us know we are going to die. None of us knows when we're going to die. So the best thing to do is have an estate plan and then forget about it. So you are neither that mother or one of those adult children facing the situation where you need care and your family can't agree about it, or you can't implement an estate plan. The mother's dementia is so advanced. You just never want to be in that situation or put your family in that situation. And that's the way to get over the hurdle. Estate plans can be changed. That's what's brilliant about them. Do them and forget about them. That's my advice.
Thank you, Bridget. Bob, what can you add to that?
So the way I present it to a client is this document, this estate document that you prepare is your last chance to communicate your relationship with your family. So that think about what you're doing and what you're saying in that document, because this is how your family is going to remember you. And I've had it 2 different ways. I've had it where I had a client who had 3 children. The daughter was a gambler. And she kept on going back to her mom. I need money, I need money, I need money. And mom knew she was gambling. Her siblings knew she was gambling. And when she did her estate plan, I attended the meeting with the attorney. And I said to my client, don't give her the money outright. Put it into a trust. She's not responsible. And the mother agreed with me. But she said to me, I will not treat one child differently than the others. She said, that's not the message I'm sending to my children. They're all equal to me. If she decides to take her money and throw it away, that's her issue. It's not mine, but I will not do that to her. And then I had another client who was the opposite. He did not have a good relationship with his daughter, and he made that clear in his will by leaving the assets 60% to his son and 40% to his daughter. And even worse than that, many clients have a selection process of personal property. How does personal property get split between the beneficiaries? He said, my son gets the first 57 picks of my personal property, and then after that, it's 1 for 1. So he made it clear in his documents that he had an issue with his daughter, and that he made sure that his son took the bulk of the estate. So it's your last chance to show your relationship with your family. It's a very important document, and it needs to be planned. You need to put the time in to plan it.
Thank you. Actually, have a bit of a follow-up. Both Bridget and Bob, you told interesting stories as ways of getting the point across about the emotional barriers and getting clients to focus. What is the most interesting or unusual situation you faced, particularly with personal property and sentimental items? Unfortunately, I have been a witness to what can happen on questions of personal property, sentimental value more than financial value. What sorts of situations have you seen there? Because I think it's easy to forget about the record collection if it's not worth all that much, or the jean jacket or whatever. What have you seen with your clients? Matt, why don't you start?
Well, it's I'd like to tell a little different story. This is not one of our larger clients, but this I think is one of my favorite points in a 48-year career. I had good friends that had a small business, and one of them, Chuck, did not believe in insurance at all. And they were like good Americans. They lived at least 105 to 110% of their current earning power. And they belonged to country clubs and all this other stuff. So they didn't believe in insurance. When I put in their group health insurance, I purposely added group life insurance because I knew Chuck wouldn't buy any. Then we installed a pension plan, and we were able to install a pre-retirement death benefit that his partner agreed, and we sort of pushed it through. And then we had a small buy-sell agreement, very small, to pass the shares back and forth. And Chuck did not like his son-in-law, who was a kind of a bum, and never got along with him. And when Chuck passed, he was a good-looking guy. He just had a bad heart. He was writing his bills one day and just fell over on the table. And I happened to be away at the time he passed away. And I got a call, but they were friends, so I rushed back, and his wife, Roberta, was in such a tither because she knew they had no life insurance, right? And she had all these expenses and this nice house and a mortgage. And I showed up, and the whole family's there. And Dennis, who was the bum, is saying to Roberta, he's the son-in-law, "Don't worry, Roberta, I'm going to take Chuck's place in the business. Everything's going to be fine, this and that." And I went, "Well, excuse me, let me tell you Chuck's wishes." I said, because not only do I know what happened with the buy-sell and the pension, I have all this stuff. I said, I also have a message from Chuck. I go, so here's what's going to happen, Roberta. You're going to get 100,000 group life insurance. You're going to get 400,000 of a death benefit plus the assets in his pension plan. You're also going to get another 550,000 for the buy-sell agreement. And those assets are going to take good care of you. And by the way, Dennis, did you notice 550 of that was Chuck selling his shares to Alan? Now, Alan owns 100% of the business. And here's his message to you. You're a bum, get a job. That is we have lots of clients. I have lots of stories. That's my all-time favorite story because they were my friends also, and I lived that story. And Alan, we helped him get a new partner, buy in, and then an exit strategy. And Alan's retired now, and Bill, who bought in, owns the business 100%. So I have lots of second, third, and fourth generation stories. But for whatever reason, maybe because I enjoyed saying, Dennis, you're a bum, get a job. This is my favorite story of all our planning cases.
Thank you, Nat. Bob, can you top you're a bum, get a job?
No, I can't top that. That's a tough one. But personal property is usually in most estates not very valuable. I'm an executor of an estate. The estate is worth over 20 million. The contents of the apartment were valued by an appraiser at about $25,000. Yet that was where most of the time as executor was spent, because we'd sit in a room with the beneficiaries, there's 3 beneficiaries, and every time a piece would come up to talk about, I had to hear a story. You know, this was given to dad by his father. This was something mom always used for the holidays. And each kid wanted it for different reasons. And I'm sitting there thinking, this is $25,000. To me, I hate to say it, but it's junk. It wasn't worth anything. But they felt very strongly about it. And it took a lot of time to divide it. We ended up pulling numbers out of hats to decide who would get certain pieces. And there was some bad feelings about certain things. So, you know, people may say it's not very valuable, just let the beneficiaries handle it. I think you have to give more direction in that because of the sentimental value.
Thank you, Bob. Bridget?
So I have helped clients give hundreds of acres of important land to create national parks. I've also helped widows give $100 to their local house of worship. But my favorite estate plan has to be my own parents. I sat them down one Thanksgiving and said, Mom and Dad, I'm an estate planning attorney. Now I teach wills, trusts, and estates. If you don't execute an estate plan, you are going to professionally embarrass me, because all of my students will know that my parents had no wills. And only then could I shame them into executing estate planning documents. And it turned out in both of their final illnesses to be very important. My father lived in Ohio. I'm here in New York. And it was incredibly helpful to have a healthcare proxy designated. His brother lived right nearby, and the brother could talk to doctors, and that was super important. So I never got to tell anybody like Nat did, you're a bum, but I did tell my parents, you're gonna embarrass me. And luckily, we had some good laughs about that, and both estates went very smoothly. So whatever it takes, do the estate plan, and you can go on and live a long and happy life.
Thanks, Bridget. Thanks to all of you for your responses so far. We've left some time to be able to take some questions from the audience. And so now I'm going to ask Craig Hyland to field some of the questions that we've either previously received or that have come in through the chat since we started. Craig is the Executive Director of Major Gifts in PACE's Office of Development and Alumni Relations. So I'm going to hand it over to him now to hear some of the questions that we've gotten.
Great, thank you, Horace. I'm happy to be here today, and this was a great panel discussion, so thank you for being here. The first question came during the chat, and it's about executors. And the question is, if you have a spouse or an adult child, can they serve as the executor if they are the principal recipients of the estate? Is there a problem or a conflict?
No problem, no conflict. It is quite common for spouses in long-term marriages to appoint their spouse as an executor. It is also common to appoint adult children. The tricky thing that both Nat and Bob alluded to is when you have more than one child, if you're treating them differently, you need to make sure you're abundantly clear. Typically in New York, at least, when family members are executors of modest estates, they waive commissions, but there's no per se prohibition on that.
Great, thank you, Bridget. There's a question. There are a couple questions in here about planning and prepaying for funeral and burial expenses. If this is something that a person should consider doing, and how important that is. I think that might be a question for Bridget as well.
I can take that. It is something that we see people doing increasingly, especially with the COVID pandemic. Many of us have contemplated that very precise issue. So it is something to look into. It is also a major profit center for funeral homes. So consider that as well. I don't recommend it for everyone, but if you have a very small estate, that's something you might want to think about, especially if you're in the below the $200,000 range and you know your family members are not in a position to step up. I would say you're in the range of wanting to think about that, but make sure, like anything, you shop around, because funeral homes make a lot of money that way.
Nat, it seems like that would be a way to provide liquidity, as you talked about earlier. But it seems like, and correct me if I'm wrong, you could pursue other types of insurance products, not necessarily through a funeral home, in order to achieve that liquidity. What are your thoughts on that?
I think there is. That's not really our market. Funeral expenses it's not an issue for us. But I know there are products but we don't handle them, and we would be referring that person out to a different firm than ours.
Thanks.
Thank you. The next question, do homeowners need a trust to avoid probate? Can it be a will instead of a trust that would avoid probate for property transfer?
Bridget, what do you think?
If someone is pushing you very hard on avoiding probate, they are trying to sell you something. It is very, very difficult to avoid probate entirely, because even if all of your assets are held in non-probate form, like joint tenancy, there's going to be some little asset that you have to probate the will over anyway. If you want to pass your house, does it have to be in trust? Absolutely not. Are certain types of ownership facilitated by trusts? I would say yes, indeed. Not necessarily the family home, but generally speaking, that's not a tax savings device. And people who will try to scare you into avoiding probate are selling you something.
Great. Thank you, Bridget. There have been a few questions about the various differences in estate taxes, and particularly what are the benefits of moving to Florida, and is that a way to avoid estate tax? I think that question was directed at Bob.
Yep, I'll take this one. So many states, in fact, over 35 states, don't have estate taxes or inheritance taxes. However, there's another 19 or 20 states that do have an estate tax. So many people, when they realize that, try to move out of a state like New York State, for example, which Nat said is a very high tax rate, that you can get trapped in this so-called cliff version and pay more than 100% tax rate into New York State. So there's a lot of motivation for moving out of New York State and into a state that does not have a state tax. And the prime example is Florida. The issue comes down to domicile. You have to show that you're domiciled to Florida, that you're not domiciled to New York State. And domicile is really, where is your heart? Where do you intend to come back to? So if you say I'm moving to Florida and you maintain your Park Avenue apartment or the home you raised your children in, the New York State's going to argue you really didn't change your domicile. What you did was you became a snowbird. You go down to Florida for the winter, you come back in the summer. You still have the Picasso on the wall. You still belong to the religious services. Your main doctors are still in New York City or New York State. So you haven't really changed your domicile. The best way of doing it is selling your major home in New York State, buying a big house, a nice house in Florida, change your affiliations, move all your near and dear items, make all the steps to show that I'm not coming back to New York. Yes, maybe I'll maintain a one-bedroom apartment in New York City because I come up to see shows or I have family here, but my major assets have moved. So it's very important. It's a tremendous tax savings. So, but it has to be, again, very thoughtful.
Thank you, Bob. We had a couple questions about the cost in doing a power of attorney, healthcare proxy, and a will, and what should be expected in a rate for an attorney to do that for you. Hey, Bridget, you have thoughts on that one?
It absolutely depends. You can have an estate plan done for $2,000 and you can have one done for $20,000. The most important thing is that you be upfront with whoever you're working with about what you feel comfortable paying. Obviously, you don't get to set your own rate, but the attorney will try to work with you. You can do some of these things on your own through online providers like LegalZoom. I'm not endorsing it. I have no stake in it, but there are some self-help. but self-help can be tricky. So I would say self-help would only be in an emergency situation. Otherwise, reach out to attorneys that you know and ask for a referral based on the size of your estate and what your price points are. You should not expect to do it for, gosh, at an absolute minimum, I think $500, depending where you're located, but that can easily, with client counseling, costs accelerate quite quickly. Always ask the attorney how they bill, whether they bill hourly or for the job, and be upfront and expect the same from your attorney as well.
Thank you, Bridget. Nat, I have a question for you. Until what age can a person buy life insurance?
Actually, you can purchase insurance into your 80s these days. It's, the only one who's buying insurance in the 80s are, very wealthy people that have an enormous estate. But I would say this, people should buy insurance, or at least try to get a good understanding of what the financial instrument can do for them, right? Earlier in their life, because what most people don't realize is a properly designed insurance portfolio will help people have either larger income stream from their other assets, right? Because it can function basically as a bond, and it gives them the stability of their income. So as an example, most people today, if you go to any financial planner and you say, I have X amount of money, what's the right amount that I should take every year? 95% will say 4%. They'll say 4% is, that's what you need to take every year so you don't run out of money. But think of it this way. If you have $1,000, right? And now when you have to take out your 4%, that $1,000 is $900. So that $400, right? Well, that $40, right? To $900 is not 4%. It's higher than 4%. If the stock market went up and those assets are worth $1,100, you've taken out less than 4%, right? So what happens is, with a properly designed insurance portfolio, when the market goes down, you can take retirement money from your insurance policy. When the market goes up, you take it out of your asset base. So what happens is, when you design it properly, people can get anywhere from 10 to 18% more life income just on a disintermediation. Most people think of life insurance as you live or you die, right? It's an absolutely much more valuable, flexible financial instrument that can go with your portfolio and help you turbocharge that for lifetime income.
Thank you, Nat. I'm going to ask one last question, and then if we didn't get to your question and you submitted it, we will follow up with responses to them all. And this one I think would be for Bridget, but I think Bob or Nat, if you have anything to say on this, please jump in. How best can you prepare for the proper care of a pet after you pass? If there's no one within your family or circle of friends who is able or willing to take care of your pet, what alternatives are out there?
It's funny you asked that. We did we called it Pooches and Ponies at the Wellington Polo Club in Florida. And it was basically, how do you take care of your pets? And by the way, it's an enormous business. When I first heard about it, I'm saying, oh, it's a dog, it's a cat, right? No. People give away their livestock. I mean, the enormous amount of animals that need to be cared for at people's demise. One of the things that we do is we have a little bit of an expertise in pet trusts, but we won't deal with people that won't have a wealth replacement trust also for their family. In other words, we are not going to allow what Leona Helmsley did, leave 10 million to her dog, who I think ultimately got 2 million after the children sued, with something like that. So we've made a professional decision that we will do no pest trusts without an accompanying wealth replacement trust. So if you want to give 2 million to a dog, a cat, or to take care of all my cows, then you better replace, put an insurance policy in there and replace $2 million to the family, because the animals can't get more than humans. So that's my experience with pet trusts.
So in New York, we specifically have a pet trust allowed by statute. So if you don't have a lot of livestock, but you've just got a cat or a dog, there is a way to make sure that they'll be taken care of. You need to nominate a trustee of that trust, but especially if there's a commission involved, you can usually find someone who's willing to act as trustee. So assuming that you aren't leaving your kids out in the cold, there are vehicles for taking care of just small household pets, and you should talk to your lawyer and your advisors about that too.
Thank you. Horace, turn it back to you.
Thank you, Craig. So that's all the time we have for today, but I want to thank everybody for participating. Thank you for your questions. Thanks to our panelists for their answers and their insights. As Craig said, if you submitted a question that we weren't able to get to in the time we had today, you will get a response. You'll get a response from us later. But please, everyone, join me in whatever form you like, either on your screen or virtually, in giving a hand to Nat, Bridget, and Bob for, again, sharing their insight and experience with us today.
Welcome.
Thank you.
Thank you.
Thank you.
Thanks
so much.